so I'll hand over to you to begin your presentation.
Thank you. My name is David John Harvey. I'm a retired District Court judge. I currently hold a practicing certificate as a barrister, and I have a Bachelor of Law degree, a Master of Jurisprudence degree, and a Doctor of Philosophy degree. I support the bill, and I believe it should proceed. It's a matter of such importance that I think it should be properly placed before the electorate by way of a referendum. I should say that although I'm a lawyer, I neither endorse nor support the submissions of the New Zealand Law Society and the New Zealand Bar Association. Turning to my submission, I focus upon Clause 6 of the bill, although it's critical to note that the bill does not in fact rewrite or amend the treaty itself. That is made clear in Clause 9. The committee, of course, will be aware of the principles that are contained in Clause 6. Principle 1 confirms the governmental structure of New Zealand in terms of what would be called a liberal democracy. Principle 2 secures property rights and by implication incorporates the concept of rangatiratanga, because that was a right that Māori enjoyed when the treaty was signed. Principle 3 provides for equality before the law and the equal enjoyment of fundamental human rights. The entablature of the United States Supreme Court building has the phrase equal justice before the law. That is what Principle 3 is all about. The courts, government and Waitangi Tribunal have developed a number of principles which it is argued will be excluded by the bill. I argue to the contrary. If we look at Principle 1, we have the power to govern New Zealand in the best interests of everyone. This incorporates the principle that the Crown has the right to govern. Edmund Burke considered that society is an enterprise that promotes the interests of all parties, and that partnership depends upon respecting those interests. The government, therefore, is a partnership between the people and the state, and thus the principle of partnership is necessarily preserved. As part of a partnership principle, there are a number of collateral elements. The active protection principle is inextricably linked to that of partnership. Given that Māori are a constituent part of everyone, the active protection principle ensures the protection of their interest. Implicit in any partnership is the principle of good faith dealing. If a government excludes good faith, it loses legitimacy and will fail. When there is a breakdown in a partnership relationship and wrongful acts are done by one partner to another, there is a right to recompense and adjustment, and thus that principle is present. The recompense principle is also recognised and given effect in Principle 2 of the bill. Thus, in my argument, the existing principles of partnership, active protection, equity and fair dealing and remedies for wrongs are included in Principles 1 and 2 of the bill. I have approached the problem in the way that I have in an effort, I hope, to dial down the rhetoric and emphasise reason. And I am at your disposal if I can be of further assistance.
Thank you, Judge Harvey. We've got a couple of questions. First one from Willie Jackson, and then Rāori Waitangi.
Kia ora, Judge. Kia ora, Judge. Judge, you're out of sync with the best legal minds in this country. That you'll be aware of that. The King's Council, the creme de la creme of legal minds in this country, who have come out unanimously against this bill. You're out of sync with the creme de la creme of political leaders in this country, like Sir Geoffrey Palmer, Sir Doug Graham, Chris Finlayson. I just can't reconcile this, Judge, given your background and your status. Where does this put you in terms of the legal fraternity? Because the legal fraternity seems almost unanimously against this bill.
Firstly, Mr. Jackson, not all King's Council are of one mind on this particular point. Point 2, Mr. Finlayson made some interesting suggestions in his submission, as I recall. I wonder if he's looked at his watch lately, because in fact, we have daylight saving, which is the way in which time gets changed by parliamentary action. So the suggestion of parliamentary supremacy that he sort of disposes of so rapidly doesn't stand. It may well be that there are differences of opinion, Mr. Jackson. That's what living in a democracy is all about. I have approached this from the point of view of reason. Other people have approached it from the point of view of rhetoric and buzzwords. That's their privilege, of course. We live in a democracy. They have freedom of expression. It bothers me not one whit if I am out of sync with other people, or as you put it. I doubt that I am, but you're entitled to your opinion, as I am to mine.
Absolutely, Judge. Yeah.
Start from Willie and then we'll go to Rāori.
Yeah, absolutely, Judge. I would concur with that. Would you agree that this is an attack on the Māori tino rangatiratanga? That has been the constant criticism here. Do you agree with that?
No, I do not. And if you read my submission, you will find it.
Thank you. Rāori and then Todd and then Doug.
Morena, Judge. Thank you for your submission, firstly. And just to pick up on some of the stuff you talked about before I get to my question, especially around the equal rights for all in America. As we know, the civil rights movements didn't just come out of thin air and out of reason. To pull a rhetoric like that, where civil rights was only established in 1954 to 1968, I think does them an injustice. Māori are 30% of the people proceeded against by police, 45% of the people convicted, and 52% of the people in prison. And after that presentation, I understand why. Now, as a judge, do you respect the rule of law and 30 to 40 years of jurisprudence by the Supreme Court, by the Privy Council, by the High Court, by the Waitangi Tribunal, who have ruled in favour of Māori when it comes to treaty rights?
Do I respect the rule of law? Of course I do. But the point that you make is an interesting one, because if you read my submission and if you understand it, you will note that the principles that I have referred to are those that have been devised by the courts and by the Waitangi Tribunal. So there is no difficulty whatsoever in the incorporation of that jurisprudence into the submission that I have made. And I have said that those particular principles fold into this particular bill that is before the Select Committee at this time. So of course I accept the rule of law. It would be completely alien to my nature to feel otherwise.
If that's the case, then why would we have the need for this bill?
Because it's time that this sort of thing should be clarified. I think that there has been a lot of confusion about the way in which the principles of the treaty work. It is a matter which concerns every New Zealander and therefore should be put before every New Zealander.
Thank you.
And that is why I support it.
Thank you, Judge. We're going to go to Todd and then Duncan and then Tamaki.
Thank you, David. Thank you for your submission. And I've got to say, I think it was very interesting the way that you've been able to incorporate the current principles of the treaty as it's understood into this proposed bill. But my question, I think it follows on actually just from what you said. I mean, you see this as a totally legitimate discussion for Parliament to be able to have and then in the future to go to a referendum of the New Zealand people.
Yes, absolutely.
Todd, Duncan and then Tamaki.
Good, Judge. Look, I'm just interested to draw on some of your experience in the District Court, where I have no doubt that you had a long line of defendants in front of you.
I sat in South Auckland, Dr. Webb.
Yeah, so in light of that, you would have seen the disproportionate representation of Māori in our criminal justice system, and I'm sure you would have seen cultural reports. How do you reconcile that with the suggestion that we should be narrowing down the scope of the treaty?
I'm not suggesting for one moment that we should be narrowing down the scope of the treaty. I refer you to Clause 9, which keeps the treaty in place. Furthermore, I refer you to the way in which I've developed my argument, which is that the principles that have been developed by the courts should be incorporated. The problem that we have, in my view, with the greatest of respect, Dr. Webb, is a political one. And it flows from the fact that successive parliaments, both Labour and National, have failed to grasp the fact that the changes that are needed to get rid of this terrible disproportion, and it is a terrible disproportion of appearances in court, is not a 3-year problem. It's a multi-generational one. It's going to take 25 years to solve, and it requires a concerted effort on the part of everybody to
Thank
deal
you.
with it.
Thank you, Judge Harvey. So I'm sorry to interrupt, but that's the end of the time this morning. We appreciate you coming online and joining us early this morning. Thank you for your time.
Thank you.
Right, members, just before we go to the next submission, I just want to make 3 very quick points. If members can keep their questions succinct, if we can get more questions in from other members, there are.
Okay, thanks, Stacey, for that. Right, so Ray, I have questions. I have so many questions about that submission.
Yeah.
You know, I mean, so he's a judge, right? He wants to put this bill before the electorate, despite the fact that it was not developed in consultation with Māori. I would like to know, with him being a judge, if I was in the room, I would ask him this question. How's that ethical? Why would you not consult the group of people that this bill is going to impact the most?
He suggests that it was done with, or was it Waitangi Tribunal? They were...
Well, the tribunal...
There's a redacted submission.
Yeah, the tribunal was not consulted in the development of this bill. David Seymour ignored working with Māori organisations and ignored working with...
Oh, right, during the formation of what they've put forward. Yeah, okay.
Yeah. So so there was a lack of consultation. Now, I want him to, as a judge who upholds the idea of democracy, how is that ethical? If you're developing a bill that's going to impact a significant population of the country. And take into account the history of past Crown breaches. I've put an entire record in the chat.
It's the most common thing is the mistrust, and that's also, you know, I Māori and their core concepts like manaakitanga have demonstrated that is a culture that I would trust, and they should be making laws.
Yeah, I mean, if you were in the room with him, what question would have you asked him?
It's difficult because a lot of this is explaining systems that I wasn't even aware of, and it just gets too complicated for me, actually.
Yeah.
I thought I was intelligent, but it's so, you know, I'm thinking, oh, this is good. Like that, maybe that was my initial when I started reading the bill. Sorry, we're having that type of summon. When I started reading the bill.
Yeah, I mean,
I thought, okay, this is good, right? But
it brings into question, you know, with him working as a judge, it brings into question, is he as a judge, has he given special privileges to Māori in when he was working as a judge in the court and in his rulings? I would have liked to have heard examples from him where he had to give special rights and privileges and uphold the special rights for Māori in the court. That would have been really fascinating to hear. And I'm going to have to look up this guy's submission if he's included those, because again, this is a thing that that I'm hearing time and time again from people who support the bill. They don't present which laws disproportionately favour Māori over Pākehā. I'm starting to find that's a real common theme here.
What is it actually changing as well? Because you're saying Clause 9 refers to this, and it's not. We're not actually removing the legitimacy of Te Tiriti. What is the bill actually changing?
Well, the bill, what it effectively does is
I shouldn't ask.
It changes the government's obligations when it comes to upholding Te Tiriti. So they're basically reinterpreting how it can be upheld. So it's moving away from the 3P.
Yeah.
It's already a conservative interpretation of Te Tiriti that was developed by the tribunal back in the 1970s.
Yeah.
I mean, I'm not a lawyer or a judge either, by the way. If you know, so don't feel too. I mean, I'm just as confused as everyone else here. How he as a judge could kind of like it makes me want to look into his work history. All right,
Yeah, and I'm curious as to why they say, like, you know, 95% of your fraternity are at odds with what you were saying. So it's definitely one to put a pin on.
That would have been really interesting to hear kind of more in detail where he disagreed with them and what points. I didn't really get that from him.
Yeah.
All right, so we're ready to move on to the next one.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.